Ready, start. The respondent contends that segregation was necessitated by the mandate of this court in Ashwani Kumar Upadhyay within bracket supra bracket close, which requires expeditious disposal of criminal cases involving elected representatives. It is further stated that direction was purely procedural and intended to obviate delay caused by the abscondence of certain co-accused while ensuring that the trial of the appellant proceeds in a timely manner. Before addressing the question of the legal permissibility of such segregation, it would be apposite to extract the relevant portions of the trial court's orders dated 28/8/2024 and 2/9/2024 as affirmed by the High Court. A plain reading of the above orders makes it clear that the segregation was directed solely on account of the appellant's status as an MLA so as to facilitate a day-to-day trial in purported compliance with the directions of this court in Ashwani Kumar Upadhyay within bracket supra bracket close. Significantly, the record discloses that no notice was issued to the appellant prior to passing of the segregation order, nor was there any application filed by the prosecution seeking such a course of action. The segregation was thus ordered suo motu without affording the appellant an opportunity of hearing. The statutory scheme under the Code of Criminal Procedure 1973 is clear. Sections 218 to 223 lay down the framework governing the joinder and separation of charges and trials. Section 218 embodies the general rule that each distinct offense shall be tried separately. However, the code carves out specific exceptions to this rule in sections 219 to 223 where joint trials are permissible in the interests of justice. Applying the aforesaid principles, we are of the considered view that the order of the trial court directing segregation of the appellant's trial from that of the co-accused cannot be sustained. The only ground recorded was the delay occasioned by the non-appearance of certain co-accused. The proper course in such a situation would have been to segregate the absconding or defaulting accused, not the appellant who was regularly before the court. By doing so, the trial court inverted the settled principle and thereby committed a manifest error. No finding was recorded that a joint trial would delay proceedings or cause prejudice to the appellant. Reliance placed by the respondents on Naseeb Singh's case is misconceived. The case concerned consolidation of two distinct FIRs arising from unrelated acts. It does not support the arbitrary splitting of a joint trial. Indeed, it reinforces that joint trials are not only permissible but preferable where offences arise from the same transaction and evidence is common, provided no demonstrable prejudice is shown. This court has consistently held that a fair trial forms part of the guarantee under Article 21. Departure from established legal procedure, particularly without hearing the affected party, constitutes a serious constitutional infraction. The segregation order passed suo motu by the trial court falls short of these requirements. A unilateral order for a separate charge sheet and segregated trial passed without notice or application violates the basic principles of procedural fairness inherent in Article 21.